With a U.S. Supreme Court decision validating the process, Oklahoma is moving forward with 3 executions that have been on hold for months. The nation's high court ruled the 3-drug cocktail the state uses to carry out the death penalty does not violate the U.S. Constitution.
Within hours of the U.S. Supreme Court's decision upholding the state's lethal injection protocol, Attorney General Scott Pruitt notified the Oklahoma Court of Criminal Appeals that 3 inmates had exhausted all of their appeals, which starts the process toward execution. Reaction to the decision from the High Court broke down along political and religious lines. Governor Mary Fallin says she appreciates the court's ruling, and the Constitution is clearly not intended to prohibit the death penalty by lethal injection or the use of the sedative midazolam. Dale Bache, one of the attorneys for the prison inmates who filed the suit, warns, despite the unwillingness to step in on this important issue, and given the substantial risk of harm, litigation surely will continue. Oklahoma City Archbishop Reverend Paul Coakley prayed for the day that Oklahoma and other states will abolish capital punishment, a statement that shows how the case the court decided and the issue of the death penalty itself cannot be separated. Ryan Kiesel is executive director of the ACLU of Oklahoma.
The death penalty just does not work. It's arbitrary, it's ineffective, it's racially biased, it's geographically biased. It depends upon your money, on your lawyer.
Scott Rowland is the first assistant Oklahoma County District Attorney and an expert on constitutional law.
But the constitutionality of the death penalty doesn't turn on whether or not Scott Rowland personally favors it or not. It doesn't turn on whether or not Ryan Kiesel favors it or not. I think it's impossible to say with a straight face that capital punishment is unconstitutional, because the Constitution itself in the Fifth Amendment contemplates capital punishment.
Kiesel argues that the court's decision put a new hurdle in the way of anyone arguing their constitutional rights under the Eighth Amendment, that any future legal challenges from death row inmates have to include a better way to conduct their own executions.
I can't think of any other constitutional right that's conditioned upon a person having to demonstrate that the state could do something better or in another way.
Rowland counters, however, that it is not a new or unique requirement for Eighth Amendment cases.
You can look at this opinion and say the court was putting the burden on Glossip to find a better way to put him to death. In reality, what the court is saying is, when we're trying to determine whether or not a certain punishment is cruel and unusual, the question is compared to what?
Kiesel also believes the Eighth Amendment has a deeper meaning behind it as a way to show the world what America is really all about.
It's real easy to be nice to the Boy Scouts, but those same standards of decency, if we can apply them to the people convicted of the most heinous crimes, that really says a lot about us as a nation.
And Prosecutor Rowland does see attitudes toward the death penalty changing in Oklahoma because of his experiences in the courtroom.
There absolutely is a change. It seems to be a slow but gradual change to me in terms of attitudes toward the death penalty. You're seeing fewer death cases filed in Oklahoma. I believe that you're seeing juries more hesitant to give it.
Rowland says prosecutors in Oklahoma do not automatically default to the death penalty when the case fits the criteria. He says, in fact, many times, not seeking the death penalty is the best choice.
Here's what you need to be prepared for. You need to be prepared for this case to not go to trial for 2 or 3 years. You need to be prepared for about 12 to 15 years of appeal after that. And I find, in my personal opinion, many times I believe that the family of the murder victim is better served by swift, sure life without parole.
The Oklahoma Court of Criminal Appeals will next schedule the executions of Richard Eugene Glossip, John Marion Grant, and Benjamin Robert Cole. They are the 3 inmates represented in the lawsuit that led to the High Court's ruling.